We'll hear from the appellant.
Good morning, Your Honors.
Good morning.
May it please the Court, my name is Erica Blaylock, and I represent Miss Vanessa Clark, the appellant in this case. And I would like to reserve 5 minutes for rebuttal, please.
5 will be fine.
Thank you. And Your Honors, this is an appeal arising from a Fourth Circuit Court order that was entered in February of 2024, finding the appellant, Miss Vanessa Clark, guilty of 100 counts of contempt of a series of orders of protection. There's a lengthy history between these parties and a voluminous trial record, I believe, that's been submitted on appeal here today. And ultimately, this is a case about a public figure, a rock star, who is silencing the First Amendment right to free speech of a person who is posting on social media about, in particular, Mr. Sixx and his band. And this is, we are here to review a number of liberty interests here. And the first liberty interest is Ms. Clark's First Amendment right to exercise free speech. And ultimately, her freedom from incarceration for her position of exercising that right to free speech in contrary to the orders of protection that have been entered. And the
Ms.
standard
Blaylock, you'll agree with me that the First Amendment does not provide protection for speech that is threatening and abusive. I mean, threatening to kill and rape is not protected, correct?
Yes, Your Honor, I do agree with that. The law certainly supports that an individual has protection from harassing speech or threatening speech. But our position here today is that the orders that were entered go beyond that. They are overly broad and then further unduly her right to free speech beyond just that purpose. And the standard of review for contempt cases is abuse of discretion. Issues of fact are reviewed with a presumption of correctness unless the preponderance of evidence is otherwise, whereas the issues of law are reviewed de novo. And we have raised a number of issues in our brief. Firstly, the First Amendment issue that I've already spoken about. And we would submit to this court that a couple of these orders entered by Fourth Circuit Court violated her right to First Amendment to exercise her free speech. And to start off with, I want to look at the October of 2022 order. And we would argue that Ms. Clark's right to free speech is protected under a number of provisions in the law. And the first one is obviously the United States Constitution, the First Amendment, but it's also protected under the Tennessee Constitution. We would also submit that the Tennessee Public Participation Act is relevant here as well, and that is codified in Tennessee Code Annotated 2017-102 and 103. And the Tennessee Public Participation Act, or the TPPA, also provides protections for free speech, particularly regarding matters of public concern, which includes public figures. And Mr. Sixx here is a public figure. And so we argue that that's how there's more of a special analysis here in regarding to the restraint on Ms. Clark's speech. And so we would submit to the court that the October 2022 order serves as a prior restraint on Ms. Clark's speech, as it restrains her communications based on the content prior to them occurring. And there's a heavy presumption against constitutional validity of prior restraints. Strict scrutiny is required to determine whether a fundamental right has been violated. And strict scrutiny requires that the restraint on speech be narrowly tailored to serve the compelling government interests. And the restriction must not be overly broad or vague and must specifically address the harmful, unprotected speech without unduly burdening constitutionally protected speech. In the October 2022 order that Fourth Circuit entered, Ms. Clark was restricted from using a couple different types of hashtags related to Mr. Sixx. She was also restricted from utilizing or posting the names of Motley Crue's band, past and current bandmates, as well as the band itself, any of their albums and/or commercial activities. And it also restricted her from any posts regarding Mr. Sixx, his wife, his children, or just about him in general on social media or any electronic media. And so we would submit to the court that the scope of the order of protection as defined in the Tennessee statute, which is codified in 36-3606, provides protectioners for a petitioner and their children if the children are listed. And notably, Mr. Sixx's minor child, Ruby Sixx, was listed on the initial order of protection in July of 2021. However, she was not listed on any of the subsequent orders of protection. And also, as an aside, Mr. Sixx's wife also had an order of protection in 2021 that expired. And she is not before this court on this order of protection. And so we submit to the court that the restrictions of Ms. Clark posting about his wife or his children or these additional public figures, being the very famous band Motley Crue and the bandmates, and even extending to their album and commercial activities, goes beyond the scope of the order of protection statute, and further, it undulies her burden or undulies her right to First Amendment free speech regarding those other matters. And so we would submit to the court that posts mentioning other people are not punishable by contempt on this statute because the statute does not provide for protections for these other individuals. And looking at specifically the order entered by Fourth Circuit Court in May of 2024, setting forth Ms. Clark's bond conditions, we would argue that this order itself also violates Ms. Clark's First Amendment right to free speech. And the order sets forth that Ms. Clark may not access or post on any of her current social media accounts or create any new social media accounts during the pendency of this appeal. And the Supreme Court discusses the importance of social media as a public forum in the case Packingham v. North Carolina. And in this case, the Supreme Court held that the North Carolina statute was unconstitutional because it violated the First Amendment free speech clause. The statute prohibited sex offenders from accessing commercial social networking websites if the offender knew that minor children could become members or create web pages. And so the Supreme Court discusses how social media is one of the protected forums in the First Amendment. And in this case, the Supreme Court stated that to foreclose access to social media altogether is to prevent the user from engaging in the legitimate exercise of First Amendment rights, even convicted criminals. And discusses
Let me ask you this, just as a practical matter. What is your solution then to the problem of threatening posts like the ones that your client posted? I mean, if you're saying that, you know, she's posted these threats of violence against the petitioner and his daughter and his wife, an order of protection was entered against her, multiple ones, she violated every one by continuing to post. You're saying she has a First Amendment right to do that. What is the solution for people in the petitioner's space? What are they supposed to do? Just continue to allow it because you say the First Amendment allows her to post it?
No, Your Honor. I believe that there is a remedy for the petitioner in that the petitioner can file the order of protection and can proceed on contempt for those types of posts, for the threatening or harassing types of posts. But I believe that the scope of the order of protection that was entered by the court goes beyond that and restricts her beyond that. And so I'm not standing before the court today saying that Mr. Sixx does not have a remedy or that he is not able to pursue action against Ms. Clark for those types of communications. But I am saying that her First Amendment right was unduly burdened beyond that purpose, and that the order goes beyond that and does not meet strict scrutiny for that purpose. And so,
I'm sorry, counsel, help me here a little bit on the procedure, I guess. Were any of these order of protection, just the orders of protection themselves, appealed?
no, Your Honor, they were not.
The only thing that's on appeal is the finding of contempt related to the violations of the order of protection.
Yes, Your Honor, that's correct.
Is that a problem?
And I'm sure that counsel is going to address that in his argument in just a moment. But the orders of protection were not appealed. However, I do not believe that that cuts off Ms. Clark's remedy in asking the court to review the Fourth Circuit's order in restricting her First Amendment right to free speech. And I think there's a couple different mechanisms for that. And I do believe that that is important to note that in the October 2022 hearing, Ms. Clark was pro se. She did not have counsel available at that time to represent her and assist her. I do also believe that the Tennessee Rule of Appellate Procedure, Rule 13, also allows the court to review questions or issues that are not necessarily presented, but to prevent needless litigation, injury to interests of public, or prejudice to the judicial process. And I believe it also allows for review of any question of law that's brought up. And we would argue today that this is a question of law of whether the orders of protection unduly burdened her right to free speech.
Okay. You've used your time. You have your time for rebuttal.
Thank you.
Thank you. Hear from the appellee.
May it please the court, I'm Wade Davies here on behalf of the appellee Nikki Sixx. The appellant in this case, Vanessa Clark, has engaged in a pattern of threatening and harassing behavior against Mr. Sixx and his family now for years. And after full hearings, the trial court has repeatedly found that the conduct and the contact violated the Tennessee stalking statute. The court has entered valid orders of protection that were carefully thought through as far as the remedy, and rather than object or appeal those orders, Ms. Clark just decided to continue to violate the orders. And so this is not a First Amendment case. This is a case about the fact that if a litigant disagrees with an order or the scope of an order, she has to appeal that order. There's no right to unilaterally declare an order invalid like the appellant has tried to do here. And so the way that these orders evolved is that back in 2021, because of Clark's repeated unwarranted contact and threats of Mr. Sixx and his family, the trial court issued orders of protection prohibiting the appellant from contacting Mr. Sixx either directly or indirectly, including through the use of posting hashtags that go directly to, for example, Nikki Sixx Pics, which is one of the websites that he uses for business. And so the appellant here tries to frame the case as a celebrity trying to silence someone. So I think it's important to look at the types of conduct that this case involves. It involved originally posting a picture of Mr. Sixx's 2-year-old child, hashtagging Mr. Sixx and all of his accounts, and suggesting that this child would be killed, posting and contacting Mr. Sixx with a picture of his wife and child on a trampoline with a target or crosshairs posted across his wife. And these kinds of things happened repeatedly. They were found to be stalking. The appellant continues to post portions of those same postings time after time, no matter which order is in place. So this appellant knew that she was prohibited from posting to Nikki Sixx pics, for example, because she stopped doing it until the date that the original order of protection expired. And so then she started doing it again. And after the original order of protection expired, she came back with new posts about how now her life is in danger and the court found that she needed to have a gun. And these are very disturbing posts to anyone reading about himself and his family. At the October 2022 hearing, this appellant testified that she was allowed to have her gun and she needed it because Mr. Sixx was threatening her life. So she's saying that she feels threatened by him and needs to have a gun. So the court held a full and fair hearing in October of 2022, made findings of fact, and this is all about contact. It's not about the contents or about the First Amendment. It's about contact in violation of the court order. And the court made findings of fact that she knew from a previous trial that Mr. Sixx receives those messages, and found that the posts, made a finding of fact that the posts are false and are not protected by the First Amendment. These repeated posts about Mrs. Sixx allegedly drinking while she was pregnant, or the child not really being Mr. Sixx's child, or the claim that Mr. Sixx was actually stalking her. There is a finding of fact made after a hearing that those are false and not protected by the First Amendment. So the question here is whether the appellant violated the court's orders. And it is extremely clear that she did. And on appeal of a contempt petition, the only issues are whether there is a lawful order. And lawful order doesn't mean that someone can just unilaterally say the order isn't lawful. All lawful order means is that it is an order that was entered by a court with jurisdiction. So there is no question that the orders in place were lawful orders. The second prong is whether the orders were clear in what they prohibited. There is really no question about that. And in fact, Judge McMillan gave this appellant every benefit of the doubt of that. For example, finding that certain prohibitions of the 2022 order weren't specifically written in the 2023 order, so he didn't apply those, despite the fact that in open court, he had said that all of the provisions would carry over to the 2023 order, but on that date, Ms. Clark had chosen not to appear. So he gave her every benefit of the doubt as to clarity of the order. And then the third issue is whether there's a violation. It's absolutely clear. Whether the violation is willful. There couldn't be a clearer case of willful misconduct when the person is posting that she's aware of the orders and that she's not going to follow them. So there really is nothing else for the court to address on appeal, because all of those factors are clearly established by the record. The appellant has never really articulated how it would violate the First Amendment for the trial court to prohibit stalking, because that's what this is about. And what is prohibited by the orders is contact. It is a no contact order. The court has made findings of fact about certain ways that this appellant attempts to violate that order by contacting Mr. Sixx either directly or indirectly. there's an issue that has been raised on appeal about the orders being overbroad because they allegedly protect other people. That's not what the orders do. The orders make findings of fact about ways that this appellant tries to evade the orders through indirect contact by posting and hashtagging people who are close to Mr. Sixx who provide him with the postings. The two issues that are attempted to be raised here have both been clearly decided by this court before in Purifoy versus Marfa. And in that case, there was likewise an electronic stalking case resulting in an order of protection. In that case, the stalking was committed by means of posting onto YouTube or Facebook. And the first issue is whether that is contact. And the court clearly held that it is. The court said on appeal, Dr. Maffa argues that the Facebook videos he posted on his own Facebook page don't constitute contact because he didn't post them on her Facebook page. The court upholds the findings of fact that posting those Facebook videos did, in fact, contact the victim. Our case goes even further because there were previous findings of fact that posting and using these hashtags is a form of contact to Mr. Sixx, and Ms. Clark was informed of that finding of fact. In fact, the trial court even read his order to Ms. Clark and confirmed that she understood what she was not allowed to do. She confirmed through her testimony that she understood she is not allowed to do this. And what she did was she just decided to do it anyway. So it is a clear and willful violation of the court's orders. As far as being tailored, when you look at the history of the case, the original order was just a typical no contact order. The court used its form. The October of 2022 order was narrowly tailored to the conduct because the court took into consideration the history of this appellant's misconduct, narrowly tailored the order to prohibit the forms of unlawful contact that Ms. Clark was engaged in. So the order was narrowly tailored. And then the bottom line on the case is that if this appellant really believed that there was a problem with the orders of protection, she could have appealed them. And that is something that applies in all criminal cases. I cited the recent Court of Criminal Appeals case of State versus Stack, where essentially the exact same thing happened. Stack was placed on probation for a sex offense. The court issued conditions of probation, which included not using certain forms of the internet. Stack did not appeal those conditions of probation. Instead, he tried to raise an overbreadth argument after violating them and being hauled back into court for a violation of probation. What the court said in that case is very interesting. If you have a problem with an order of the court, you have to appeal it. You can't wait and violate it and then raise your issue, because the court said that that would encourage noncompliance with the court's orders, and that's exactly what has happened here. And then the further issue that this court has already ruled on in Purifoy versus Maffa is the fact that these Facebook or video posts do not violate the First Amendment. And just as in here, the court said Dr. Moffa's repeated video and written postings about Ms. Purifoy were part of his course of conduct of stalking. His repeated posts were clearly meant to harass, degrade, intimidate, threaten, and humiliate, and they had the desired effect. The right of free speech is not absolute, and the court goes on to say that speech is often a factor in stalking, and it is not protected by the First Amendment. So at the contempt trial, the court was presented with, I think it was a total of 110 counts or something like that. The trial court looked at each one of those postings and issues of contempt very closely, gave her the benefit of the doubt on quite a number of them, did not find her guilty of contempt in a number of cases, went through and made detailed findings of fact that each one of those instances of conduct violated the court's prior orders. So what happened in this case is that this appellant was subject to valid court orders. She chose to violate them repeatedly. The violations were clear. The court found her guilty after giving her every benefit of the doubt, and so the contempt convictions should be affirmed.
Thank you. Hear from the appellant in rebuttal. Counsel, can you give me an example, a specific example, where you say the trial court order violated your client's First Amendment? Which one of those can you just, and I know you probably say more than one, but can you just give me one that you say this is an example of where the trial court violated my client's First Amendment rights?
Yes, you're right. Yes, Your Honor. An example would be that that Ms. Clark was prohibited from even posting about Motley Crue's albums, for example. That would be one example. It's extending beyond Mr. Sixx and protecting other people. I know that counsel has argued that that order is not protecting other people, but rather indirect contact attempts towards Mr. Sixx. And Ms. Clark would disagree with that assertion.
But was she found in contempt for making some statements concerning the ban?
Yes, Your Honor. There were findings of contempt of her hashtagging Motley Crue, hashtagging the bandmates.
It was the hashtag. Is it the hashtags that you have the problem with? Because you say the hashtags don't directly relate to Mr. Sixx. They're broader than that.
Yes, Your Honor. And the hashtags is just one part of it. The court actually restricted her from posting about Motley Crue's, even, like I said, commercial activities going beyond just the hashtags. But there were several hashtags that were specifically listed in the October 2022 order that she was restricted from utilizing.
Did the trial court make a specific finding, though, that your client was using the hashtags and using that content, even though it didn't directly mention Mr. Sixx, that she was using it because she knew that it would get back to Mr. Sixx, so it was therefore an indirect contact? And if the trial court made that finding, how are we to overturn that?
Your Honor, I think ultimately the court found that in the counts of contempt against the October 2023 order. And the reasoning there was where the October 2022 order specifically restricted her from doing these specific hashtags or mentioning specific people. The October 2023 order does not do that. And so instead, the October 2023 order restricts her from attempts to communicate or contact Mr. Sixx indirectly or directly. And so the court continued to find Ms. Clark in violation of that order based on the reasoning that those further hashtagging other band members or those types of things were an indirect type of contact towards Mr. Sixx. So that reasoning was applied in terms of the October 2023 order, not necessarily the October 2022 order, as that was specifically spelled out in the 2022 order, but not the 2023 order. And so, and that goes to our argument in as far as contempt as to those counts from the 2023 order. We submit to the court that, as counsel stated earlier, that a lawful order has to be clear, specific, and unambiguous, and it has to expressly and precisely spell out the details of what someone can do or is prohibited from doing under that order. And so we would argue that because the October 2022 order was so specific, that when the October 2023 order replaced that order and did not include these specific prohibitions, that a reasonable person could understand that those specific actions were no longer restricted. And the court did make a finding of fact that that was an attempt to indirectly contact Mr. Sixx. And, you know, we would submit to the court that the evidence preponderates against that.
I would just challenge your statement generally that a reasonable person would think that any of the comments that were made by your client were acceptable.
And Your Honor, that statement is based on specifically the use of hashtags, not necessarily the content of those particular statements. And again, as I argued earlier, we understand that there is a basis for protection based on some of the posts if they're threatening or harassment. But we are arguing that the order extends beyond that into unduly burdening her First Amendment right to free speech beyond those types of posts. And so we would submit to the court that the October 2023 order did not specifically prohibit her from hashtagging, for example, Motley Crue or their band members, and that her testimony that she did not believe hashtagging constituted contact preponderates against the evidence for that finding of fact. Thank you, Your Honors. We would rely on our briefs for the remainder of the arguments.
Thank you, counsel.
Thank you.
Our thanks to counsel, both counsel. We appreciate your briefs and your oral argument on this.